children, XG, D, S, and AS were all in the vehicle with you, correct?
Correct.
On the day of the wreck, XG was 9 years old and is currently 12 years old, correct?
Correct.
DS was on the day of the wreck 1 year old and is now 3 years old, correct?
Correct.
And then finally, your last child, AS, who was involved in the wreck, was 2 years old and is now 5 years old, correct?
That is correct.
And you took your 3 children after the wreck to the hospital, is that right?
That is correct.
And all 3 of them were checked out from that visit over at Medical City, Dallas, correct?
Correct.
And as a result of that, the doctors performed evaluations and discharged the children, correct?
Correct.
And no other follow-up visits with a pediatrician or any other primary care doctors were necessitated for your 3 children that were involved in the wreck, right?
Correct.
And after that, you have not taken them since to any doctors for any complaints for injuries that they received from this wreck, such as a pediatrician or any other doctor, right?
Correct.
Okay. Now, there was a settlement that was reached between yourself and all the named defendants on behalf of your children. You understand that that's the driver and the company for the other vehicle that was involved in the wreck, as well as your auto insurance, Allstate, for some personal injury protection funds, correct?
Correct.
Okay. And as a result of your children receiving that medical care and being discharged, you believe that they have reached or their injuries have resolved and there's no lasting conditions from being involved in this wreck, right?
Correct.
Okay. And you understand that a settlement was reached for each one of your children. And that settlement is something that we are here for today to ask for the court permission relating to your belief that each child's settlement is in their best interest. Is that right?
Correct.
Okay. You understand that your right to a trial by jury has been explained to you?
Yes.
And by reaching a settlement, a jury, your right to a trial by jury, you understand you will not be able to bring that to finality, and that by reaching a settlement, the children could receive more or less or the same if this case went to trial, correct?
Correct.
And you believe that the settlement for your children is in their best interest, and you're asking the court to approve this, right?
Correct.
As it stands today, you don't have any out-of-pocket expenses relating to any of your children's visits or medical care or damages that they sustained, correct?
Correct.
Okay. Now I'm going to go over some specific numbers for each, and I need just confirmation from you that that is correct relating to your understanding for their settlement numbers, as well as the net recovery for each child. Okay.
Okay.
For XG, my understanding is that he was with the other children present at the hospital, did actually have a quick one over from the EMS, but did not have any medical charges, correct?
Right.
Okay. But still examined real fast and told, okay, no need to get any additional medical care, right?
Right.
Okay. Now, as a result of that, there's a settlement that's reached with the named defendant for the driver and the company that was involved in the wreck, and that is not including your auto insurance's personal injury protection policy. That settlement was for $1,200 as a gross settlement. You understand that to be correct?
Correct.
After attorney's fees, that means that there's $800 that is going to XG for his pain and suffering and involvement in the wreck. Does that sound correct?
Right.
Okay. And then for DS, when he was involved in the wreck, again, went to the hospital, and those services have been paid by his Medicaid insurance, correct?
Correct.
There was a settlement with the defendant trucking company as well as the driver for $3,000, and a settlement with your personal injury protection policy for $3,144, meaning a gross settlement between all the named defendants of $6,144. Does that sound correct?
Correct.
And there were attorney's fees of $2,190.94, and then expenses paid for the medical bills and records for $243.08. And then finally, there's a payment going to Medicaid for $274.39. Does that all sound correct?
Correct.
After taking all those deductions, that means that there is a net recovery for DS in the amount of $3,435.59. Does that sound correct?
Correct.
And then finally, for your last child, AS, same result. No, excuse me. There was a gross settlement with the named defendant driver and trucking company for $2,500, and a settlement with your personal injury protection proceeds through Allstate for $3,144, making a total settlement of $5,644. Does that sound correct?
Correct.
Attorney's fees for $2,024.27. $240.60 were paid for medical services, medical bills and records that were received in affidavit form. And then we have payments going to Medical City Dallas for $133, and payments to Quest Care Medical Services for $683. The Medicaid coverage for AS at the time did not cover this visit. Does that sound correct?
That is correct.
Okay. And because of that, after all those deductions, we have $2,563.13 that is coming to AS for his injuries and pain and suffering. Does that sound correct to you?
Correct.
Okay. Now, as we sit here today, you had an opportunity to meet or discuss with the ad litem relating to your children. Does that sound right?
I'm sorry? Here.
He's gone.
Did he lose
Everything okay?
connection?
Yeah, we lost Chris.
Why don't you go ahead and ask any questions you have, Brad?
Your Honor, I don't have any questions. I would like to make one point of clarification, if I may. I
Sure.
heard Mr. Provost state that his attorney's fees with respect to the minor DS were $2,190.94. They're actually $2,109.94. And so the document that's been submitted to the court, the proposed final judgment, does have the correct numbers in it. I think he just misspoke.
All right, no problem.
And I apologize about that. I believe I got cut off there.
No
Mrs.
worries. Any more questions, Mr. Provost?
Just Mrs. Sparza, you believe that the settlement for each of your children is in their best interest, correct?
Correct.
And you're asking the court to approve those settlements, right?
Yes.
We pass the witness, Your Honor.
All right,
Your Honor, I have no questions, Your Honor.
thank you. And Mr. Westmore, I think you had no questions. Mr. Greeting, did you have any questions?
I just have one or two, Your Honor. Mrs. Sparza, it's Robert Greening. You and I have spoken on the phone. I think we spoke on the phone 2 or 3 times. Is that correct?
Correct.
And during those conversations, I made sure that I answered all of your questions about this settlement. True?
True.
And you understand that this is a final settlement and you can't come back to the court on behalf of your children to obtain any more money regarding their injuries in this matter. Do you understand that, correct?
Yes.
And you and I spoke about what to do with this money, and we decided that the best thing to do with it is to ask the judge to place it into the registry of the court. And you understand that it will be placed in the interest-bearing account for each one of the children, and they will be eligible to receive that money on their 18th birthday. And you understand that, correct?
Correct.
And are you asking Judge Hoffman to approve the settlement?
Yes.
And you believe it's in the best interest of all three of your children?
Yes.
All right, I'll pass the witness. Thank you.
All right, ma'am, Mrs. Sparza, do you have any questions for me?
No, sir.
And you want me to go ahead and approve this settlement?
If you may.
Okay. All right, it's a recommendation of the guardian ad litem.
Yes, Your Honor, the guardian ad litem requests that you approve the settlement and the attorney's fees and expenses as stated by Mr. Provost in his questioning and as contained in the judgment. I believe that this is in the best interest of all three of these children, and I think that the best way to have this money safely available to these children when they turn 18 is to just place it into the registry of the court. So I would ask that you approve the settlement as stated in the testimony in the judgment that is in front of you here today. And I've submitted an order for my my guardian ad litem fees, Your Honor, and I believe that those are approved by Mr. Westmoreland and Mr. Scudder, and they're going to half those.
Okay. The court will approve the settlement as requested. I see that the fees, I want to make sure I have this correct, are $3,772.25. Is that correct?
Yes, Your Honor, we filed an amended order because we had a few filing expenses, and so it's $3,772.25 plus $25.44 for some filing fees. And that's in the first amended order on guardian ad litem fee that was filed earlier today.
And Your Honor, we also left a blank in the final judgment, and if Your Honor wants to fill that amount in the final judgment, and that was agreed to by Mr. Westmoreland and I as well.
Mr. Westmoreland, are you agreed?
I am, Your Honor. We're in agreement with the fees and that expense as well of 2544, and we're going to split that between the defendants.
Do you want me to include that it's going to be split equally in the judgment, or do you want me to just include the amount?
I think you could just
We
include the amount. We've got an agreement on that, Your Honor.
Yeah, we trust each other, Your Honor. That's fine.
Sounds good. All right. Thank you, Mr. Greening, for your service. The court will approve the guardian ad litem fees as agreed to by the parties. Ms. Esparza, I hope your children, excuse me, are recover from their injuries, and you guys are excused. Thank you so much. Have a great rest of your day.
Thank you.
Real quick, Your Honor, could I ask one point of clarification?
Sure.
Allstate Art, I don't know what Penske has done, but Allstate sent its checks to plaintiff's counsel several months ago. And so I assume that with respect to the payment into the court's registry, plaintiff's counsel will be handling that.
Yes, Your Honor, or Brad, Tiffany gets the application to submit to the registry, and then gets the social security cards and everything. So it'll be going. But for defendant Penske, if they want to send the checks to us or to the court registry, we can handle either.
Why don't you send us an email of how you'd like them to be?
We will handle that.
Perfect.
Okay, and I'll get you guys a W-9.
Okay, Robert.
Okay,
Thank you.
thank you.
Thank you.
Thank you, Judge.
Thank you.
No.
Great rest of your day.
You too, Judge.
Okay.
Mr. Bell, what are you here for, sir?
Good afternoon, Your Honor. How are you?
Good. How are you?
Good. I have a Rule 91A motion to dismiss that was filed back in September with regard to this case. I have a pro se plaintiff in this matter.
This is Jones v. Gorman.
Yes, sir.
Okay. Yeah, it's not 2 o'clock yet, so we'll just kind of hold off at this point.
Yes, sir.
And so we'll just wait for